So you'll know there's some changes coming for our labour laws, and the Labour Law Amendment Bill would appear to remove at least one legal protection for higher paid workers. So at the moment, if you're fired and that firing is found by a procedure to have been unfair, you would be paid out, but you'd also be reinstated to the position. One of the proposed changes is that if you earn above 1.8 million rand, you would be paid out, but you would not be reinstated. Jonathan Goldberg is the chair of Global Business Solutions. Jonathan, good evening. What is the motive behind this change? And I suppose if you earn 1.8 million rand a year, you're probably a decision maker in a business. And is that part of the thought here? They don't want to have to force a company to re-accept a decision maker, someone who could have a big influence on the firm, that they have fired.
Good evening to you and your listeners. I think that's the intention. And around the world, you do see lesser protections for higher paid people, mainly on the basis that the higher you paid, the much better you can negotiate your contract and your exit. And I think, we've started, our intention was very noble in the South African labour legislation space, but I think we just got tied up in too much litigious matters, too much litigation, and specific for high paid people who really shouldn't be clogging up the courts or the Commission for Conciliation, Mediation and Arbitration. So there's an exception to that. If it's discrimination, then of course you could be reinstated, so protected disclosure of discrimination. But beyond that, this figure of 1.8 million then of course would increase by inflation each year. But I think it's a sensible approach. Remember, we've been really criticised as South Africa employment space in respect of being too legislative, too much legislation, too much red tape. And this is one of the ways, it's a small way, to just start freeing up the legislation.
Does it have any change for the payout that you receive if you've been fired unfairly? In other words, could that go up because you can't be reinstated? Or you don't have to be?
It's a great question. It's a maximum of 1.8 million rand. Again, you're a CEO and I'm trying to poach you from your current company. You're in a very strong negotiating position. If you look at all the stats, there are skill shortages in South Africa and executive positions, skill positions. So I think the higher up you go up the ladder, the more you are, the more powerful you are in terms of negotiating. And again, if you're the CEO or the CFO or the COO and the board loses trust in you, then you have to terminate, because effectively the board, especially the non-executives, are really reliant on the executives. Having sat and chaired many boards, you're really reliant on your executives doing the right thing, providing you the right information. And with 4 board meetings a year, you can be you can be fed the wrong information, and that leads to consequences. We've had some great ones in South Africa. Steinhoff, just to mention one.
I keep thinking of Peter Moyer while I'm having this conversation. He was at Old Mutual. He was the CEO. He was fired. There was a long legal battle. Is that one of the cases that people are trying to avoid or find a way around this kind of long-term bitter dispute?
There are multiples in parastatals, government organisations. There are multiple of those disputes which shouldn't really be occurring. First of all, it's bad for the organisations. It's bad for time and reputation. And in fact, you should just agree on exits. And I think we just got too used to having all this protection in labour law, where one of the other amendments that has come through, just to balance it off, is in the first 3 months of employment, no matter what you earn, you could terminate, provided it's not discrimination, without a probation period, without anything. And that's brilliant, because you want employers to, I call it tata my chance, take a chance on the lotto here. Employ Stephen, see what he's like, and if we don't really feel that you are warranting the job, then we can terminate after 2 months without any rigmarole and without any rights referred to the CCMA. The CCMA, the Labour Court, the Labour Appeal Court, all clogged up with too many disputes at the moment. We need to find ways to free up this labour market.
I referred to the constitutional provision that we are all equal before the law. So to put that into context, it doesn't matter if you live in a shack on a farm or at the Michelangelo Hotel. If you get evicted, you'll be treated equally. And that's been the case, as you point out, in our labour law too. This does create a 2-tier labour system. And I appreciate everything you say about about the power imbalance being less for richer people, about trying to give companies space to sort of move on. I hadn't thought of SOEs, but I'm sure that's a factor in someone's sort of drafting of this. But could this precedent move down the ladder and open the door one day to people who earn smaller amounts not being reinstated if they're fired unfairly. It's CEOs today could be someone on the assembly line tomorrow.
I don't think so in our lifetime. I think we have a strong constitution. The constitution is what is free and fair in an open democratic society. So the limitations, like on a restraint of trade, that I could restrain you working for a competing radio station for a certain period. So everything, and that of course goes against your freedom to work. So there are limitations on all your rights, and this is just one way to do it. Remember, this particular clause was negotiated at NEDLAC and all the others. Major agreement on many of the labour law amendments, including this one. The parties, that's Labour, business and government, all agreed that this would be a sensible agreement. So through representation and negotiation, you got this product, as well as the 3 months, because I think everyone realises you need to find more people job opportunities so they can build up their CVs. That's the real biggest problem we have in South Africa, youth unemployment.
I don't think many people who earn 1.8 million rand are represented at NEDLAC because they tend not to belong to the unions, so their voice possibly wasn't heard. But I take your point, and I don't oppose the changes at all. I think they probably do make a lot of sense. It does. I mean, one of the things that's been so interesting about these changes for me, and we're not quite at the end of the road for the changes yet, is that for a very long time, for completely understandable reasons, government has moved to try and provide more protections for workers. And if you consider what happened in the past and the inequality and sort of negotiating imbalances in our society, that really does make sense. I think you would know this better than I, but I think this might be the first time that it's going very slightly the other way and removing a protection from workers.
I think very slight removal and for the first 3 months of employment, because I think everyone realizes the problem we have with the fact that people just can't get jobs. And employers are reluctant to employ people if they've got to follow a rigmarole procedure and then land up in the CCMA, especially in the first honeymoon phase, the first 3 to 6 months as an example. So I think everyone realizes we have a crisis, and they're not major changes and they're not major invasions on people's rights. But, everything's a balancing act. You can't have great opportunities for jobs without some relaxation of our labour laws. I mean, we've had cases 7, 8 years later. We're still fighting those cases in the Labour Appeal Court or the Constitutional Court. The law wasn't designed to do that. It should be quick, efficient adjudication, and there should be some caps. Take an example. Imagine if you fired, I was dealing with the case today, a firing of a retrenchment, and 5 years later you still haven't finalised this. So the company then has to accrue potential reinstatement costs if the courts decide that these workers are unfairly retrenched. Now that is problematic. That shouldn't be happening. We should be having much quicker and more efficient adjudication in these systems. We get into a stage where it's similar to the old industrial court, where there were 3-year backlogs by the time we negotiated a new labour dispensation. Now there are up to 2-year backlogs in the labour court to get matters settled, and that's not a good thing for employees or employers.
Jonathan Goldberg, thanks very much. Really appreciate it. The chair of Global Business Solutions